All right, folks, so let's go ahead and get going. The first thing we have on the agenda this morning is the public hearing. The public hearing is held by Louisville Metro Air Pollution Control Board and is called to order, and it's being held pursuant to KRS Chapter 77 and district regulations. Notice that this hearing has been published pursuant to state law. This public hearing is being held via video teleconference. Instructions on making oral and written comments via video teleconference have been distributed. Oral comments must be presented today and must be precise. All statements will become part of the hearing and record. There are two items on the agenda. The first to be reviewed today is an amendment to the district regulation 2.08 regarding fees. Would staff please present the proposed amendments to the district regulation 2.08? Ms. Robin.
Good morning, everyone. If you'll recall, in January, the policy committee approved a motion to open the 30-day public comment period for proposed amendments to regulation 2.08 fees, which would allow the district to modify fees for individual sources as necessary to sustain programs such as the risk management plan program. These changes would be subject to regulation 1.08, which requires public notice and comment. The proposed fee change for the RMP program specifically is a 39% increase to the fees for each facility level. This fee increase is necessary to provide adequate income to cover the costs to operate this important program, including salary, benefits, and training expenses for the district and public health and wellness employees who manage this program. The comment period ended on February 17th. We received one comment during the 30-day comment period, which was addressed in the response to comment documents you all received. Absent any questions or comments today, I would recommend that the proposed regulation 2.08 be approved by the board at this time.
Thank you. Has any member of the public submitted a written comment, which you just mentioned?
No,
Or other new ones?
not today, just the one you already
Okay,
received.
thank you. Any members of the public here in the Edison room that wish to make a comment this morning on this public hearing matter? Please step to the podium and state your name and who you represent. Anybody. Besides yourself.
My name is Ebony Neal Cochran and I'm in REACT. And if this is for the RNP to be funded, I think that it's a good idea to increase the fees on the facilities.
Thank you.
That's it.
Other members of the public that wish to make a brief comment on this video teleconference? If so, please raise your hand via video teleconference you'll be called upon. Please, you can find our participants list or pressing star 3 if joining by phone. Ms. Robbins? Nobody. Okay. Any questions by board members? Thank you. The second item to be reviewed is a new regulation, district regulation 6.53 regarding emissions guidelines and compliance times for municipal solid waste landfills. Would the staff please present the proposed district regulation 6.53? Ms. Robin.
Also in January, the strategy committee approved a motion to open the 30-day public comment period for proposed regulation 6.53, which will adopt emission standards and compliance schedules applicable to designated municipal solid waste landfills within Louisville Metro, something that has been adopted at both the federal and state levels by the Environmental Protection Agency and the Kentucky Division for Air Quality. This will allow the district to adopt the most recent version of the federal rules by referring to the already published version, specifically 40 CFR 60 subpart CF and subpart B. The comment period ended on February 17th, and we did not receive any comments during the 30-day comment period. Again, absent any questions or comments today, I would recommend that the proposed regulation 6.53 be approved by the board at this time.
Thank you. Anybody registered to make an oral comment this morning?
They did not.
Okay. What about written comment? You said no.
No. I didn't see any else.
Okay. Any members of the public here in the Edison room wish to make a comment this morning regarding this proposed regulation? Thank you. Any members of the public that wish to make a brief statement or comment on this video teleconference, please raise your hand via video teleconference. You will be called upon. It's a feature you can find on participants list or pressing *3 if joining by phone. That's a no. Thank you. Any questions by board members? Thank you. This concludes the public hearing this morning. We will now call the regular meeting of the Louisville Metro Air Pollution Control Board to order. We are conducting the monthly meeting today via video teleconference. When I call your name, please say here. Jeffrey Coburn. Here. Candace Sharp White.
Here.
Thank you. Marissa Neal.
Here.
Charlie Bertolon. Here. Wayne Porter. Here. Robert Blair. Here. Thank you. Moving on to introduction, I understand we have a couple this morning.
Please join me in welcoming Evie Quall and Sam Daring to the district. Ms. Quall earned her Bachelor of Science in Natural Resources and Environmental Science from Purdue University in May 2025, with a concentration in sustainability science and minors in environmental politics and policy, political science, and sustainable engineering. She joins our program planning team as an environmental coordinator and will be responsible for the lawn care for cleaner air, grow more, mow less, and other community engagement opportunities. Mr. Daring, APCD's new communications coordinator too, also joins Ms. Paul as part of the program planning team. Mr. Daring, who earned his bachelor's degree in journalism and communications from the University of Wisconsin-Milwaukee in May 2021, brings a wealth of skills at crafting compelling stories, managing media platforms, and building strong community relationships. He most recently served as a news and sports reporter for WSAW News Channel 7 in Wausau, Wisconsin. So we're really glad to have them both join us.
Well, welcome to the team. Look forward to your contributions and help. Thanks. Quick recognitions.
Today, I want to let the board know that next week we will celebrate National Engineers Week, which was founded by the National Society of Professional Engineers in 1951, inspire the next generation of innovators, spotlight the impact of the profession, and strengthen connections across the engineering community. By number, engineers are a large part of APCD's staff. By nature, engineers are curious about how and why something works, and they are really geared towards problem solving. That includes those who work in environmental engineering and focus their careers on reducing and managing pollution to protect human health and the environment. And they do this in collaboration with others, including APCD's own environmental scientists and coordinators, as well as policy experts and attorneys. Please join me today in celebrating our engineers who make a difference every day. Thank you all very much on my behalf for the work that you do.
Thank you for your help and contribution, including our esteemed Jeffrey Coburn here as well. And Charlie Bertolon's an engineer too. The rest of us, not so much. Some doctors though.
I'll take that.
Okay. The minutes of the regular meeting held on January 21st, 2026 were distributed electronically. Any comments, edits from the board on those minutes? Hearing none, those are approved. We now move to the public comment portion of our meeting this morning. Ms. Robbins, is anybody registered to make a comment this morning?
Yes, Ebony Neal Cochran for reaction.
Oh, yeah. So again, my name is Ebony Neal Cochran. Today I have several questions related to Anderson Wood. Anderson Wood is located in the Parkland neighborhood in West Louisville. We've been speaking before this board since August of 2025 about the adverse impact Anderson Wood's operations have had on residents and those who travel through the neighborhood. Our goal is the significant reduction and ultimate elimination of exposures to fugitive dust emissions, the thick black smoke that sometimes puffs out of the stack, the intense odors of burning wood, potential for personal harm or property damage that may occur if there's another fire or another explosion at the facility. My questions this morning are related to the wood-fired boiler at Andersonwood. Back in October, the boiler was not operating and the district was told it would not be operating until November or early December. When the boiler was restarted in the presence of district staff, a potential non-compliance was identified. I have 6 questions related to the non-compliance. One, what was the specific issue that resulted in non-compliance? 2, did some of the issues the community raised have resulted from this non-compliance issue? So those issues were the thick black smoke, fugitive dust emissions, intense odors of burning wood and fires. 3, did the district give Andersonwood a deadline as to when the issue should be brought into compliance? 4, was Andersonwood allowed to continue to use the boiler while there was a potential non-compliance? 5, if the issue has been corrected, what specifically was done to correct the issue? And 6, did this non-compliance issue warrant the issuance of a notice of violation? If not, why not? It is important for us to receive answers to these questions because based on past experience, Andersonwood will be ramping up their operations in the spring. It should be important to everyone in this room that the non-compliance issue be resolved immediately, especially if that issue has ever or has the potential to adversely impact workers and the surrounding community. Thanks.
Ms. Robbins, anyone else? Are there any other members of the public in this room that wish to make a comment this morning? If so, please step to the podium and give us your name. Are there any members of the public on this video teleconference who wish to make a brief comment? If so, please raise your hand. Video teleconference. And you will be called upon. This is a feature you can find out of the participants list, or if you're joined by phone, by pressing *3. Thank you. This completes the public comment portion of our meeting this morning. There is no unfinished business. The new business relates to the proposed regulations. The district has recommended that the board adopt the proposed amendments to District Regulation 2.08 fees. Is there a motion to adopt the proposed amendments to District Regulation 2.08?
Motion to adopt.
Thank you. Is there a second?
I'll second it.
Thank you. Any discussions from the board? I'll now take a roll call. Please unmute your mics if you're on the video teleconference and say yes if you would adopt the proposed amendments to District Regulation 2.08, and no if you do not. Jeffrey Coburn,
Yes.
Candace Shob White,
Yes.
Marissa Neal,
Yes.
Charlie Berthelon,
Yes.
William Porter,
Yes.
Robert Blair,
Yes.
and I vote yes. Proposed amendments to District Regulation 2.08 have been adopted. The second is the proposed new District Regulation 6.53 emissions guidelines and compliance times for municipal solid waste landfills. The district has recommended that the board adopt the new District Regulation 6.53. Is there a motion to adopt the new regulation?
So moved.
Thank you. Is there a second?
Second.
Thank you. And now take a roll call. Please unmute your mic if you're on the video teleconference. If you wish to adopt the new regulations, please respond by saying yes. No, if you do not. Jeffrey Coburn,
Yes.
Candace Shob White,
Yes.
Marissa Neal,
Yes.
Charlie Berthelon,
Yes.
William Porter,
Yes.
Robert Blair,
Yes.
and I vote yes. The proposed new District Regulation 6.53 is adopted. No committee reports, and so that brings us pretty quickly to the director's report. Director Hamilton.
Thank you. And I'm gonna try.
Is the sound better this morning?
Yes.
Good, I'd like to.
And are you hearing from this speaker over here?
No.
We're just talking louder? Okay.
Andy is been working to try to figure out how to better accommodate the acoustics in here, and I appreciate his continued efforts as we try to make that better. So I usually like to start out with a staff report. I am really happy to let you know that I'll have another introduction next month. APC's newest environmental coordinator joined the district this week. Metro government has a 3-day orientation program, so their first day in the office will be tomorrow. But it will be my pleasure to introduce you to Haley Thayer, another environmental coordinator whose focus will be on mobile source and other emissions modeling at next month's meeting.
Does that bring you to full staff or still got some openings?
We have some openings. We're kind of holding on to those as we go through budgeting to see what we may need. But Metro will be holding a career fair on March the 10th at Slugger Field. If you know of anyone looking for a position, that is a really great place to come. All agencies will be in attendance and they'll have representatives there who can answer questions. It's a fun time. So we'll be there too. All right. It's February. Week. Today feels like spring. Tomorrow will feel like spring, and then I do see we may have some snow next week. That said, we're approaching ozone season. Unlike most of the criteria, like particulate matter or sulfur dioxide, which are emitted directly from a source, a car or a plant, ozone is formed when two other pollutants, nitrogen oxides and volatile organic compounds, combine in the ambient air in the presence of something. And so we actually have an ozone season that begins on March 1st and extends until October 30th of each year. And that's the most likely time that we may see elevated levels of ozone, that combined pollutant. We do monitor year round because we have the state's multi-pollutant N4 site here in Louisville. But we typically don't see any ozone formation in November through February. The district issues air quality alerts based on a color-coded air quality index when pollution is forecast at levels that are unhealthy for sensitive groups or worse. These alerts allow members of the public to plan ahead to reduce exposure and also to take action to reduce their own emissions. We do this forecasting here in the Louisville area with colleagues across the river from the Indiana Department of Environmental Management, and it's a lot like weather forecasting, for example. Most air quality alerts in Louisville are issued at the unhealthy for sensitive group or orange level in that color-coded air quality index level. On rare occasions, which we saw in 2023 with those Canadian wildfires, a forecast of unhealthy for all groups, which is red, may be issued, and additional steps may need to be taken to reduce exposure. I really encourage everybody as we get ready for ozone season to visit our website. We have an air quality index and an air quality alert page there. And you can find out a lot of good information about what steps you can take to protect your health as well as to reduce emissions. But you can also sign up to receive air quality alerts by text or email, or you can follow us on social media, where we always have a weekly forecast and alerts when we need to make those. Any questions about that?
Are the readings posted, what's the frequency of the reading posting? Is it daily, weekly, monthly?
When we're not expecting any adverse impacts, we typically do a couple of day or weekly forecast. You see that just coming out as it's going to be green this week. When we're in ozone season or we're seeing impacts from high particulate matter, like in 2023, those forecasts, we try to do those a day in advance or more so that people can plan ahead. Like weather forecasting, we don't always meet our forecast. We tend to err on the side of being protective of public health. So we may issue more than we actually find out at the end of the day. Good.
I read it.
All right. So this is a tortured story, and it pains me to have to follow through on this one. So in 2015, US EPA strengthened the national ambient air quality standard for ozone from 72 parts per billion to 70 parts per billion. At that time, our area was not meeting that standard, and we were designated as marginal non-attainment. That's the lowest level of non-attainment. By 2022, we had 3 years of valid certified data that demonstrated our area was meeting the standard, and we submitted a request for redesignation as a marginal non-attainment area. Now, we did this in combination with our colleagues at the Kentucky Division for Air Quality, because the area includes Bullitt and Oldham counties as well as Jefferson County. We also did it in combination with our colleagues across the river in the Indiana Department of Environmental Management, because our area includes Clark and Floyd County. Region 4, EPA Region 5, we all sat at the table and prepared our presentations and demonstrations together to be sure that we were submitting an approvable package. The Indiana portion of the metropolitan statistical area was approved to attainment within 130 days. For us, US EPA accepted our package, approved it as complete, and then waited 244 days to go out for public comment, at which time Canada caught on fire. US EPA has a policy where they will cease working on a request for redesignation if an area exceeds the standard. And we did during those 2023 Canadian wildfires. As a result, EPA had a proposed approval of our request pending. They have subsequently denied that. They did that on January the 29th. They are, however, proposing to find that our area has met the moderate non-attainment timeframe. That's important because that will prevent us from being bumped up to a higher level of non-attainment. And they are approving our 2023 exceptional event demonstration. Now, they are accepting comment on this until March 2nd. I encourage folks who have an interest to submit your comments through regulations.gov. With respect to our area, we've now demonstrated that we met the standard in 2019, 2020, 21, 22, and 23. The reason that US EPA denied us is that we again saw impacts from Canadian wildfires in 2024, and their policy prevents them from moving forward. We are in the midst of preparing with the Kentucky Division for Air Quality another exceptional event demonstration for 2024, possibly 2025, and also working to make the demonstration to bring our area into attainment. Just because our work isn't done unless some litigation is involved, Kentucky Attorney General Coleman has petitioned US EPA for reconsideration of their denial. Right now, that's just a very simple petition. It does not yet state the basis upon which EPA should reconsider the action, but we'll keep the board informed as that litigation moves on.
Couple questions. So back when it was submitted originally several years ago, is the same package submitted both district, regions 4 and 5?
The data is the same.
Data is the same?
So both the air quality data, the emissions inventory data, and our projections of where the area will be in 2035.
So once they denied that submittal in region 4, does that mean that region 5 becomes null and void as far as their approval?
No, it does not upset their approval. The approvals are state by state. So the good news is that conformity for the area has been approved in that earlier designation. That's the way that we work with our transportation partners so that their work can continue. IDEM, though, will have to take measures under its contingency plan to address the area because they too have seen some elevated readings in 24. We're also that situation is very similar to how we're situated with respect to Cincinnati, for example. They were redesignated by their region, Region 5, which does the IDEM for Floyd County in about 145 days. So they are in attainment, but have had subsequent violations. And so as part of those requests for redesignation, they include maintenance plans and contingency measures, which is the pathway that you'll take to bring your area into attainment.
Okay,
You say that you will file for a exemption, a
Exceptional
event
demonstration.
for 25 as well?
We're looking at that, 24 we know. There were 3 days in our 2023 submittal that US EPA deferred action on. We had 9 days total, 6 days brought the area into attainment, and EPA deferred on the basis that those other 3 days didn't have regulatory significance because they're not needed to show we were at 70. They now have regulatory significance. It's math. We're working with a 3-year average. So how those days may be evaluated and brought into EPA's consideration of what happened in 24, that's to be seen.
So that's 25 play into it.
It's a 3-year design value,
Oh.
so it rolls along. And that's a bit of a problem, particularly in our situation. I did a quick look this morning, and the outlook for the Canadian wildfire season, which also begins in, it's possible that we'll see holdover fires in 2024 and 2025. And these are fires that are described as zombie fires. They survive the winter by going underground in organic heat in the soil. Right now, the temperature outlook for this year is that we'll see very high temperatures and that the drought areas are going to just increase this year. And that's both for Canada and also for the continental United States.
The EPA doesn't have a built-in guideline for these type of circumstances.
They do. Each state, each local agency has to make a weight of evidence demonstration that fires either locally or, in our case, 1,200 to 2,000 miles away, which is a challenge, have impacted your area's design value.
That puts the burden on the states and not on the government.
Correct. Correct. And we as practitioners have made recommendations to EPA that particularly when there is a national event, like we saw in 2023, that they take the lead. Exceptional event demonstrations, the first one that we did, we were looking at both particulate matter approaching the 2024 strengthened particulate matter standard, I'll touch on here in a minute, as well as looking at those ozone impacts. We hired a contractor. It was a 6-figure proposition. It did give us a really great format to use. And now we're working with a climate scientist at the cabinet, but it is an impact on our air monitoring staff as well as on our program planning staff, because there are 12 different ways you have to demonstrate that ozone here in Louisville, Kentucky is actually the result of fires. So it is a challenge.
So what's the status of reformulated gas?
Reformulated gas is something that we submitted in June of last year. For those of you who are familiar with it, our area was part of an opt-in by the governor in 1996 to use a special blend of gasoline called reformulated gas that at the time burned cleaner, fewer emissions of nitrogen oxides. It also had lower volatile organic compounds come out of it and fewer hazardous air pollutants. Gasoline itself is, we now use a tier 3 blend. It's very close to what we get from RFG. We submitted a package to EPA to replace the emission reductions we received from RFG with emission reductions from the shutdown of Mill Creek Unit 1. That's still pending. So EPA understands our timeframe on it, and hopefully we'll see action on this.
So it's March 1st, the day for reformulated gas.
It's actually later in the
Is
season.
it?
We use RFG here year round, and
Yeah.
it's a different blend, as I understand. Thank you. Moving on, this is probably a big one, y'all have probably seen it in the news, and that is EPA's action on the endangerment finding and Louisville source greenhouse gas regulations. Last March, EPA came in and said that they were going to take 31 deregulatory actions. 27 of those are in the AIR program. In conversations with EPA, they advised us to take our summer vacations off of our calendars last year because they were going to roll these out as quickly as they could. Their schedule is a bit delayed. I do believe that we're going to be seeing a lot more regulatory actions here in the next week and thereafter. So we'll advise the board as they come out, but stay tuned on that. One of the ones that EPA has on the list of deregulatory actions is the 2009 endangerment finding by EPA, which found that greenhouse gas emissions, including carbon dioxide, methane, and 4 other greenhouse gases, threaten public health and the environment. This forms the basis for regulating those emissions from cars, power plants, and other industries. Last July, EPA proposed repealing the endangerment finding and associated greenhouse gas regulations for light, medium, and heavy-duty on-highway vehicles. Now, we don't regulate those vehicles, but the emission reductions that are coming from the tailpipe rule, which is what they call this one, from the CAFE standards that set how car manufacturers have to achieve certain mile per gallon milestones. It's all built into the modeling that we use to show that our area is meeting and will attain a standard. So we rely on them, although we don't regulate them directly. You may remember Ms. Robbins gave a presentation on the endangerment finding at the August meeting. And February 12th, EPA rescinded the endangerment finding and repealed all of the associated greenhouse gas emission standards for light, medium, and heavy-duty vehicles, which means that vehicle manufacturers are no longer required to measure, report, or comply with EPA greenhouse gas standards. Although fuel economy standards and reporting requirements with the U.S. Department of Transportation's National Highway Traffic Safety Administration currently remain in effect under separate statutory authority for now. Please note that NHTSA, which is that National Highway Traffic Safety Administration, in a separate action last month, proposed excluding electric vehicles from baseline mile per gallon calculations and other changes. The proposal would reduce the 2031 fleet-wide standard to approximately 34.5 miles per gallon. It's a 31.5% reduction from the previous target. NHTSA projects that proposal would increase the fuel consumption by 96 billion gallons, increase CO2 emissions by 1,000 million metric tons, result in 473 additional deaths from criteria pollutant emissions, and cost consumers $280 billion through 2050.
Or what kind of time frame?
Through 2050. Now, the good news is your car or your next car will cost you less. They estimate about $900 less.
Mobile source emission regulations, for example, for NOx, and VOCs, those still remain in place, correct? Okay.
So this is crude
Hmm?
for now. But once we change how far your engine will go on a gallon of gas, we increase emissions. We're reducing it from about 50 miles per gallon by 2030 to 34.5.
Well, automobiles and trucks will still have catalytic converters.
they will. But your mile per gallon, you're gonna use more gas.
I know that.
That's the metric. And they'll still have catalytic converters today. They've
Yeah,
not
I mean-
proposed rolling that back.
Yeah, because those 95% or so of its critical emissions.
Yeah.
Yeah, okay.
Back to the endangerment finding. EPA bases its rescission of the endangerment finding and repeal of those associated mobile source regulations on three primary legal arguments on what it now describes as the, I'm going to use air quotes a lot, so y'all forgive me. They describe it as the best reading, the Clean Air Act as it was understood prior to 2009. The first basis is that air pollution in Clean Air Act Section 202, which is related to mobile sources, refers exclusively to pollution that threatens health or welfare through local or regional exposure, and not to something like the complex global mechanisms involved in climate change. Their second basis is that under the recent Supreme Court decision in West Virginia v. EPA, addressing global climate change is a major question of economic and political significance and requires that the Clean Air Act include clear congressional authorization for EPA to regulate global climate change or to enable a transition from internal combustion engines to electric vehicles. Put a pin in electric vehicles. They're also covered in the SAFER Act, which again pulls them out of the planning for throughout the country. Third basis, because eliminating all greenhouse gas emissions from U.S. vehicles would impact global mean surface temperatures by only approximately 0.013 degrees Celsius by 2050. The regulations do not meaningfully contribute to solving the problem, making the compliance costs unreasonable and the effort futile. EPA did not use the climate science alternative basis proposed in the draft rule, which was based on Department of Energy's a critical review of impacts of greenhouse gas emissions on the U.S. climate report. If you've read the report, you may understand why EPA chose not to rely on it. I encourage you to read it. It's a very interesting read. It will likely come up at some point in these discussions and in the ensuing litigation that's going to follow here. EPA didn't offer any other scientific basis for rescinding the endangerment finding because they contend that this is a purely legal issue. EPA lacks the statutory authority to regulate in this area, regardless of what the science says. So that's their position. They did acknowledge that state and local air pollution programs like ours have relied on reductions in particulate matter, nitrogen oxides, which are precursors of ozone, and hazardous air pollutants. These are co-benefits of the greenhouse gas regulations on mobile sources to meet the national ambient air quality standards. But they believe that these co-benefits are too small to impact attaining those standards. There's more about how EPA believes its action in rescinding the endangerment finding and repealing these greenhouse gas mobile rules will be fine in the long run in the actual proposal that they've made. But they do conclude by sharing their encouragement that we continue to participate in future rulemakings for criteria pollutant emission standards for cars and other rulemakings impacting criteria pollutant emissions from stationary sources. We regulate stationary sources. Our monitor doesn't care where the pollution comes from. If we are exceeding a standard, we may only seek reductions from those stationary sources. So when we comment on national matters like this, we usually join with our national colleagues, with the National Association of Clean Air Agencies and the Association of Air Pollution Control Agencies, because our combined voices often have more impact. They acknowledged us. The only place that we as professionals in this work and seek reductions if we're not meeting a standard are stationary sources. EPA characterizes this final rule as the single largest deregulatory action in U.S. history that will save Americans over $1.3 trillion through 2055. If you'd like, I can share how EPA gets to that number. It includes the 1.1 trillion in savings for us collectively in the cost of new vehicles. They estimate that this action will reduce the cost of a vehicle about $2,400. The additional 200 billion in savings are from the avoided costs of purchasing electric vehicle chargers and related equipment. Manufacturers will no longer have the pressure to build EVs and can produce the vehicles that consumers want. Affordable vehicle ownership is essential to the American dream and a primary driver of economic mobility out of poverty in the United States. Americans rely on vehicles to reach jobs, education, healthcare, and essential services. This is especially true in rural parts of the country without public transportation. By decreasing vehicle and regulatory compliance costs, EPA is improving affordability, expanding consumer choice, and ultimately advancing the American dream by making it easier to reach jobs, grow small businesses, and participate fully in the transportation and logistics systems that power the U.S. economy. That's from their FAQ outlining the action. There will be litigation. There probably already is folks at the doorstep of the courthouse with a suit. That's not unusual. This actual finding has been litigated before. It will be interesting to see what happens now. There will also be a need to take separate action by EPA to address greenhouse gas requirements for stationary sources authorized under sections 111 and 112 of the Clean Air Act. We expect to see those at some point, and we'll keep the board informed as both the litigation and other regulatory actions take place. I may not be able to answer your questions, and I apologize for that, but please let me know if you have any.
No, time will tell. Questions for anybody? Interesting dilemma.
It's almost
Situation.
beyond comment.
Well, you wonder how much of it is this whipsaw world in which we live. And the next thing will be the whipsaw back.
This is a challenging program to implement via regulation because regulations can be changed. What we've seen, and those of us who work here, I will tell you on a personal note, we stand on the shoulders of people who started the 1970 Clean Air Act. Every day we're pushing their decisions forward, but the work that they've done is the basis of what we do. Same for the 1990 Clean Air Act amendments looking at hazardous air pollutants or air toxics. Many of the people here, some of our folks weren't even born. They've been born since the 1990 amendments. This part of the Clean Air Act that allows the EPA to find another pollutant and regulate it is a really unique part of the Clean Air Act. And I brought our staff together last Wednesday morning so that we could talk about, look, this is a once in your lifetime thing, that this regulatory provision is here and it comes through this special authority of the Clean Air Act. You should read it. It's important for you to understand that because you have the ability to form the foundation for the next 40 years of practitioners in this area. We'll see. Keep y'all informed.
Does ultimately come down to legislation passed by Congress?
Legislation would provide certainty and clarity. It's one of the reasons EPA mentioned that they were able to roll this back. From an innovation standpoint, having that certainty and clarity is really good in a program like this where you're going to need a lot of innovation. It really is hard for companies to make significant investments if the next administration comes in and changes it back again. And we've seen those flip-flops since 2009.
Well, we're seeing it here in the state, obviously, with Louisville and others.
Yes, there are consequences.
Any other questions?
Thank you. All right. EPA also took action on the cross-state air pollution rule. You might have heard about it as the Good Neighbor Plan. Under the Clean Air Act, upwind states have to be good neighbors and address any impacts that pollution made in their state may have on a downwind state. And they do that through their state implementation plan. If EPA finds that an upwind state's plan is insufficient to protect their neighbors, then EPA must issue a federal implementation plan. For a fun bunch, we often talk about SIPs and FIPS. EPA in 2023 denied the state implementation plans of 24 upwind states, and they finalized the Good Neighbor Plan federal implementation plan to address that air transport related to the 2015 ozone standard, not just from power plants, but from other industrial sources too. And there's a whole list of them, but it covered natural gas pipeline, cement and cement product manufacturing, glass and glass product manufacturing, and basic chemical manufacturing, among others. These upwind states sued EPA, and in 2024, the Supreme Court granted an emergency stay. On January 30th, EPA announced phase 1 of its plan to roll back the Good Neighbor Plan, proposing an action that would fully resolve 8 states' interstate transport obligations under the 2015 ozone standard on the basis that the state plans had sufficient data to demonstrate that they're not interfering with ozone attainment as required by those national ambient air quality standards. And those 8 states include Alabama, Arizona, Kentucky, Minnesota, Mississippi, Nevada, New Mexico, and Tennessee. So think about it this way. We've got this large country. These states are kind of in that middle of the country, and emissions from previously their power plants have been shown to have an impact kind of in that upper, the middle part of the eastern seaboard. So from Maryland on up. That was proposed too. Comment period will end in March. There'll be litigation on that as well. Keep you up to date. There are more deregulatory actions coming. I expect some soon. Any questions on that?
Do we have a local impact with our Good Neighbor Plan?
So we're not impacted by anyone else's upwind.
But we're responsible for ours.
Yes, and Kentucky State Plan includes the power plants that we have here in Jefferson County. It's all the power plants in the state. They evaluate them all, see who's making an impact. EPA now says that that plan is good. So there you go. All right, I'm going to end on happy note. I'm very pleased to conclude my presentation today, or my report, with presentation on the Air Quality Trust Fund and the Clarity Photo Competition. Once I complete my report, Flannery is joining us today virtually. She'll be providing an update on our documents that must be managed under the American with Disabilities Act and our efforts there. And then Matt King will be providing a presentation on ABC permits. For those of you new to the board, there is an Air Quality Trust Fund, which is a special fund that only you administer. The fund can be used for conducting and funding air quality research and development projects, special non-recurring air quality projects, and air quality education programs. It cannot be used to support the district's day-to-day work. Current balance of the fund is $13,881.28. There's an active link there. We have a web page that folks can go to learn more about the Air Quality Trust Fund. Next slide, Andy. Thank you. Any project that meets the criteria may be considered by the Air Pollution Control Board. If you have an idea or know of a project for the board to consider for funding, you can submit through our website. There's actually a hyperlink there that will bring up a roof form. We take a look at those, share those with the board if appropriate. The board can fund an activity. The minutes are actually what we use with O&B from the next meeting to authorize that payment. If it's not quite ready to present to the board, we'll work with folks to be sure that we get a good presentation to the board for consideration. What funds the Air Quality Trust Fund are grants, gifts, donations, bequests, civil or criminal penalties, but not those that the district assesses. You all have a role in civil penalties under CARES, Chapter 77.990, can't be self-serving. You also can't solicit funding for the Air Quality Trust Fund. If you have questions about that, county attorney has an opinion we can share with you on that. Any questions about the Air Quality Trust Fund in general? In the past, it's been used to fund some electric vehicle chargers, Jefferson Memorial Forest, and a charger at the Healthy House in Portland. It also provided funding for a solar panel array at our Cannons Lane in Cornwall site. Okay. This is the really good news. So we have a sensor manufacturer. It's Clarity Movement. We have several of their sensors. These are small, low-cost sensors for particulate matter, black carbon, and other pollutants. And they set off a photo contest last year, asking folks to show their equipment in action. And that's the competition. Those were our competitors. Next slide, Andy. I'm really happy to let you know that Natalie Smith, who is an APCD environmental technologist, submitted the winning photo. And with it comes a $500 prize that the district is recommending we provide to the board for the Air Quality Trust Fund. Board, care to receive that funding in the Air Quality Trust Fund?
Sure. Absolutely.
All right. Any questions?
Any So let me ask a question. So obviously the ability to get funds into it is fairly limited. How is it structured? You know, can you change some of this, like not soliciting is an impediment to have funds?
Comes out of CARES, Chapter 77, Section 1.27. So that's part of our limitation there is because of that statutory grant that authorizes it.
So it requires them to change it, stay.
Yes, the General Assembly would need to do that. It is held in an interest-bearing account and it receives interest annually though.
And you had mentioned grants were possible. What type of grants are there and how?
So grant opportunities come from a variety of different places. You know, we see them from both US EPA as well as private philanthropic organizations.
Just like any nonprofit seeking grants.
Yes,
Okay.
but the board would have to put together a proposal. We'd have to take a look and make sure that wasn't some solicitation. But we can work around that if you know of something that might be beneficial. We had a really good project that we knew of.
Okay,
We could look into that for sure.
okay. Thank you.
Thank you very much. Any other questions? The Assistant Director O'Neill.
Okay.
What?
I'm sorry, Charlie.
I have a parallel question to this. When we look at source pollution, and let's say a certain industry or certain site has a problem, do those sites have access to state grant funding to correct those problems, like what is offered to new businesses or something?
I would assume so. I will let you know that in the past, there used to be funding for something we call P2, or pollution prevention. And that included funding of a pollution prevention center at the University of Louisville. And that group in particular, not just for those who did have a violation, but for any business. They would come through, evaluate for efficiency and opportunities for reductions in pollution as part of their work and funding. The district has a small business environmental assurance compliance program. We're required to have that under the Clean Air Act. Certain companies, small businesses who run into compliance issues, they may, heavy emphasis on them, be eligible to go through that program and take certain steps to avoid a civil penalty one time. And it's a very structured Clean Air Act program, but it is intended to may have challenges with keeping records, for example. Believe it or not, we find that some small businesses are challenged by a 12-month rolling total. So getting them worksheets to assist them with making sure that that's an easier process for them to do and assure compliance going forward is one of the things that that small business environmental assurance and compliance program can do. There's one in the state as well.
Okay, because I have a certain idea in mind that they solve the problems.
Who's up? Henry,
Okay, you ready?
ready?
Well, good morning. Sorry I can't be there in person, but battling a little bit of a head cold, so wanted to keep everyone safe and healthy. As you all probably noticed, we have a new presentation for our board packet this month, so I wanted to talk about the reason why that is and then walk through how to navigate the board packet and solicit any feedback from the board that you might have with this new presentation. So on February 24th, 2024, the U.S. Department of Justice updated its Americans with Disability Act regulations, and that included requirements of how to ensure that information that is posted as on the websites or mobile apps can be accessible to people with disabilities. And they set a deadline for attaining these new regulations of April 24th, 2026, which is coming up quite soon. These new rules apply to state and local governments. So we here at Louisville Metro are working on this. I know that our state and local counterparts all across the country are working on it as well. Louisville Metro has a large implementation group working on this, including numerous folks from our team. So the largest changes that you'll see will be that we are trying to transition as much as possible away from using PDFs and making adjustments to settings on our web pages and our dashboards to make sure that we are following these accessibility guidelines and that the material that we post online and make available for the public is as accessible as possible. So starting with this month's board meeting, we will be presenting board materials in a web-based format. So you do not have to click through to open up PDFs. As much of the content as possible will be published directly on the website and not in a PDF. The PDFs, the reason why we're moving away from PDFs is they can be really challenging for people to navigate through, and they're not easily, it's just not a good presentation for web viewing. It's really more for printer viewing, and they require additional review and repair to make sure that they are meeting all of the accessibility guidelines, which can cause, there can be quite a length of time that it takes to review those documents depending on the length. And I know that you guys have seen some of the links that we have, or the number of pages that we have in some of our PDFs. So where possible, we are trying to move that content directly onto our website. So what I'm going to do is just a quick walkthrough or scroll through the new board packet. And then at the end, I'll pause and just ask for feedback from the board as we continue to refine this new presentation. So Andy, if you'll scroll down just a bit to the agenda section. So all of the content is the same. It's just a new look and feel presentation. So we have the agenda is presented here. There were a few PDFs that were linked in this month's board packet. Those are PDFs that have been previously posted to the website. Right now, if we want to post PDFs to the website, they do have to be reviewed through our IT department, and there is some time. It takes a variety of days to weeks for them to review them and get those back to us. So that is why the majority of the content now is going to be web presentation. So we're scrolling through. You'll see the agenda, how you access the WebEx and how to make public comment. And you can keep going down, Andy. And then when we get to the board report section of this is now in what is called an accordion feature, which you can toggle open and closed to read the various reports. So we have our meeting minutes, our air quality report, enforcement status summary, excess emissions, and our complaint investigation status summaries. Those are all contained within these collapsible accordion functions. So Andy, if you'll just open one of those, you can see how you can open and close that accordion to access the information. And the air quality report has a lot of charts and graphs. So we are also providing supplemental data tables so that if a user is not able to interpret the graph that we're showing or the chart that we're showing, there's supplementary data tables so that they have an alternate way to access that information. Another key highlight of these new accessibility guidelines is also making sure that the color contrast on the images that we use and the text colors, that there is good color contrast so that people can discern whether in those graphics. So we've made some adjustments to some of the images in that air quality report to better meet those color contrast guidelines. So I will pause there and just ask if board has any questions or has any issues with accessing the content in this new presentation so that we can address those.
Comments, anybody? I was like, no. A question though, I mean, so information that comes from the regulated community, does that include requirements on them to produce documents in this fashion?
No, this is a requirement on us, and I'm just going to ask folks to please give us some space and grace here. We've been trying to be as transparent as we can be by putting online notices of violation. Anything we can get online, we're getting it out there. When we talk to consultants who are helping screen materials, they're a little bit shocked that what we don't have are things that look like electric permits. What we do have are permits that are 400 pages long. That screening process, they're looking at every document that will go up. it may take them some time. We're trying to do everything we can on the front end to assure that our template meets the ADA requirements, to reduce the amount of time they'll need to review our materials. But we expect, at least in the near term, as we approach April, that they're going to have a backlog of materials, and it may require, may slow things down. Things will always be available if you call us. We can't email it to you because that too is an ADA. It requires that email attachment PDF to be ADA compliant too, but we'll make copies of it.
So that was kind of the genesis of my question is, somebody submits a 400-page permit to you. Are you saying that it goes out to review to some third party to make it compliant?
No, they'll submit an application to us. We'll work with that application, as Mr. King's going to explain here in a moment. It's when we develop that draft permit. It's when we develop our exceptional event demonstration or our state implementation plan. That once we provide those as a PDF to go on the website for public comment, it has to be ADA compliant.
Well, I'm still not getting it, because they're gonna submit stuff to you that they generate themselves, the permit applicant, right? Maps, diagrams,
Yes,
flow charts. Who converts those?
we do. Obligation is on us.
So the permit, you would post the permit, but then it would be compliant, this regulation, right?
That's our understanding, is that's the plan.
It's just, so therefore it has to be accessible through web browser, not PDF, right?
There are,
When you post it.
Flannery, you want to share the difference between the upgraded reviewed PDFs?
Yeah, so there is a process where we can have our PDFs reviewed, and they call it remediated. Any issues that are found, accessibility issues, can be repaired, and then it is acceptable to have those PDFs available. Wherever possible, we're trying to move content onto the website so we don't have to go through that review process. But once a PDF gets to be a certain number of pages, it doesn't make sense for us to try to, put 400 pages into a 400-page document into a web page. So we're still in the process of figuring out what's the kind of page cutoff of what we will convert to a web page versus leave as a PDF and run it through that review process. So that's the kind of grace that we're, as we navigate these new rules, that's what we're, kind of still testing out and figuring out what works best for us and for our needs to provide our content publicly available.
We're not exactly in this alone. Our state counterparts are also working to take similar materials and make them ADA compliant. They're also on the same deadline. Our colleagues at EPA had an earlier deadline. They have shared some of their best practices with us recently, and that's very helpful. I will let you know that Metro government cut us off from being able to post anything to the website ahead of the deadline. That was a bit of a surprise. So Planner Charlie is chuckling already. It's big and it's important. We'll do our best to comply. Our focus is on transparency, and we'll try to make sure that everyone on the not APCD side who's working to review these documents understand our need for speed and getting our information out. So please bear with us as we go through the process. We'll let you know if we run into any hiccups other than trying to meet that deadline and get it right.
Thank you. And just a comment for members of the public, if they have feedback or questions for us, you can either reach out to us at 574-6000 or email us at air@louisvilleky.gov, and we'd be happy to either walk you through this or help or respond to any suggestions that you might have for us.
Charlie has a question.
No, I have a comment. Not a
Charlie
question.
has a comment.
From past experience with these forms. If you are a normal citizen looking to make a comment on these forms, They are not easy to work with. They are challenging. You've got to go from place to place. And this is with me and another director of engineering from a major corporation, having done and been in you folks' roles commenting on a concrete plant that went in our neighborhood. It's not easy to work with. So anything that streamlines that and helps it is a good thing. That's my comment.
Thank you. Matt's going to talk about how our permits are actually structured. I will let folks know that the structure of our permit is something that EPA reviews when they do our program evaluations. And, it's an iterative process. If you have an example, Charlie, of a permit you've worked with in other jurisdictions that you find easier to navigate, we're always looking for recommendations and best practices.
I'm not sure that any of them are easy. But they have some different nuances and ways that they do it. Like Portland, Oregon is very different than Boston, Massachusetts. It's very different than here.
All right, good morning, everybody. I'm Matt King. I manage the agency's industrial permitting section. I'm going to talk a little bit about Clean Air Act permitting. First off, we want to thank Flannery and her team. This ADA compliance seemed a little scary a few months ago. We're not doing the lion's share of the work her team is, but it's going okay, and I think we'll get there. It's applying nationwide, so we'll get this figured out. It's a challenge, and they've been putting a lot of work into it. We have a couple visual aids, if y'all will just take a quick look and pass those down. If anybody wants their own copies, I'm happy to provide them, but I didn't want to print them out. All right, so we're going to talk about Clean Air Act permitting. I will note it's an important part of the Clean Air Act, but what makes the Clean Air Act work so well these last 55 years is the entirety of the Clean Air Act. So this is just one piece, and it takes all the many pieces to achieve the improvements in air quality that we've seen. Slide. All right, so first, who writes the permits here? What's the team on the permitting section? And I will differentiate quickly. I'll talk about industrial permitting. The agency also issues asbestos abatement permits, gas station permits, and open burn permits. Those are a little bit different. So this is about those industrial permits. But we have two sections within the industrial permitting section. One is supervised by Karen Thorne, one by Shannon Hosey. They're both here today and quite often at our board meetings. Each section has 4 engineers. It's kind of a mix of disciplines, a lot of chemical, but some mechanical, electrical, industrial. My education is agricultural engineering, but I like to remind folks that we're all environmental engineers. But really it takes that diversity of discipline to really help us understand the different sources. And then the statute that establishes air districts in Kentucky requires a air pollution control officer. At our agency, we have 2. I'm the air pollution control officer over the permitting section. Stephen Gravett is over the compliance and enforcement section. The statute requires that we be licensed professional engineers. Sometimes you'll hear that as a PE, professional engineer. And we have several folks with that licensing here. Karen Thorne, Ichu Lin, and David Becker. Next slide, please. All right, so what are the different sources we regulate? Again, this is set off differently from asbestos gas stations and burning permits. But we have our large facilities that most people think about when they think of air pollution. Major sources, we'll call them Title V, which is the section of the Clean Air Act that covers their permitting. Things like power plants, auto factories, chemical plants. Then everybody's favorite acronym, FEDUP. That's our kind of mid-size category, federally enforceable district origin permits. Those are facilities that have a potential to emit. That's if they run at full load all the time to be major. They take voluntary limits to be a synthetic minor or a FEDUP source. Think of like your printing presses that typically don't run around the clock. A lot of our distilleries are in the FEDUP category. And then we have minor sources, or you'll hear them called sometimes true minor sources, low potential without any limits. Paint shops, metalworking facilities, but really a variety of sources around Louisville. All right, and then kind of the structure of permits. There's 2 main functions and types of permits. This really applies to those major and FEDUP sources. Our minor sources get 1 permit. We update that with any new construction. But The more traditional approach through the Clean Air Act is to have construction permitting. You'll hear that often called pre-construction permitting or new source review. Those are issued per project. They're issued before that construction starts. You can clear land and do grading and build support structures, but the actual emission units, their foundations need a permit first. It's not really going to dictate how the construction is done. It's not about strength of concrete or dimensions of steel beams. It's really about getting in early. If you're requiring controls that weren't in the original plans, they will have the time to build that in both in space and in design. And it can at times for large construction permits involve some case-by-case determinations. You'll hear us throw out the term BACT, best available control technology. That's triggered for large sources. And again, that can be a little tough for the company to know without interacting with us. So we want to get in early and before they start building. But most of the conditions in those permits are very similar to the same thing you're going to see in operating permits. And then operating permits are a source-wide permit. They cover all the conditions for all of the operations. They're renewed every 5 years. At that renewal, again, we're not building in new standards, but we are verifying that all new regulations are in that permit. Any construction permits are rolled in, and any new or updated, more efficient monitoring or testing is applied at that time. Next slide, please. All right. So it really starts with a good application. I've handed out an application. It's for some abrasive blasting or shot blasting of some steel parts at a tank manufacturer. Folks come in and say, we need a permit quick. What can we do to get a quick permit? We always say, get a really thorough application to us. That is the best way. So once we want them to describe the project and the facility as a whole, provide process flow diagrams, especially for things that aren't built yet. That really helps us. We can go out and see it. That's the best way to learn about a facility, but pre-construction, you need a good diagram. We want design capacities to help with that potential to emit. We want actual operating scenarios to get a better idea of what they really will emit. They need to put in estimated emissions, applicable regulations, any proposed monitoring and testing. A lot of that's required specifically in regulation. A lot of time it's not, and we're happy to hear their thoughts. Of course, we'll review that and put what we think is best in the permit. We need information about control devices and then any requested limits. That may seem like an odd concept, but most limits are mandatory. But if you want to, say, become that synthetic minor feed source, that's a voluntary program. But once you volunteer, they become very enforceable limits. So folks need to
and those are
enforce them.
typically a reduction in emissions.
Excuse me?
They're typically a reduction in.
Reduction from that potential. You don't see many people do that against their business model, but that concept of potential to emit full capacity 24/7, that's just not real for many facilities. Power plants, a lot of them do that, but so they'll come in and say, hey, our potential looks like this. We'll take a limit. We get to lower those potential emissions and apply the different categories. All right, next slide, please. This will be really hard to see up here. I apologize, but it's not as much to give you the detail, but that's a form for abrasive blasting. That's out of the application I've shared. There we're going for, the airflow through the unit, what type of unit it is, what its efficiency is, design parameters this is the abrasive. So how much material can be abraded? What are you using? Are you using glass bead, grit, sand, the different shot medias? Good bit of technical information for us. Next slide, Andy. And then if the company's planning to use a control device or if they know we'll require one, there's also application forms to provide data on those control devices. Next slide. But a lot of folks will give us the technical sheets from the manufacturers. A lot may provide previous testing of the actual control device or maybe testing of similar control devices at sister facilities. Things like that, but it's a good packet. This one's fairly straightforward, but it's a lot of information that helps us, again, with that understanding of what they're trying to do so that we can apply the right regulations and get a good, effective permit. First allows them to proceed with their proposal, but also to make sure we have the tools to identify what compliance is and then how to verify that compliance. That's really a big part of permit writing. The standards are typically very straightforward. There are some differences of opinion on applicability of regulations, but typically you can tell if a new unit or existing unit is subject to a regulation and what the actual emission limits are. Where it becomes really work at this is to decide if the reg is not specific, how much do you verify that compliance? How much testing and monitoring is needed? And that's where you can really, in my opinion, make a much better, more effective permit to ensure that compliance. First, to keep a facility in compliance, but also to give the folks living nearby, and certainly our inspectors, the tools they need to verify that compliance. It's really a challenge for your everyday resident to do that, but we try, and these documents are a helpful tool in that process. All right, so we saw the application. This is out of their existing permit, but it's a very similar shot blasting or abrasive blasting process. They're trying to clean up that steel that may have built up some rust or corrosion on it before they do any welding or painting of that. So they run it through a machine. That machine has those built-in filters. Obviously, you generate a lot of dust as you're throwing small particles and eroding that corrosion on that metal. And in this case, we've required them to daily check a pressure drop. So if you think of forcing air with pollution through a filter, if it goes real easily through that, you're not going to catch those small particles. And if it really builds up that back pressure, you could create leaks or tears that would allow that pollution to get out. So for a process like this, we work with the company and their manufacturer. If there's any stack testing data, you get a pressure drop that signifies it's operating properly. That can be monitored continuously, it can be checked manually. We establish those ranges, and that gives a final check. Those facilities, if they are concerned with the operations of their equipment, they're going to be checking that most likely more than our permit requires. But this is kind of a keep honest people honest technique. It gives us traceability. It gives us recourse if they're not tracking this. Hopefully it addresses problems before you have those tears in the filter or some misalignment of that filter and see that excess emission occur. So again, that's really the crux of permit writing. A lot of these regulations are specific, but a lot aren't. So we'll look at just a couple quick ones of those and wrap this up. All right, so boiler regulations, there's kind of a starting point for a lot of new engineers. We still burn a lot of fuel to process and heat things. And so boilers will heat usually water, send that out to heat a process vessel or space heat, generate electricity at a power plant. And those are typically regulated at both the local level and the federal level. So here at APCD, we have a boiler regulation for new boilers, regulation 7.06. It clearly sets the limits, PM, opacity, SO2. That again it's not simple, but it's the easier part of drafting a permit. It differentiates between solid fuels like coal and wood or liquid and gaseous fuels like natural gas or diesel fuel. But it does not contain, it's an older regulation, any specific monitoring, record keeping, or reporting. And again, that's what the permit engineers do to build that permit. It's a kind of a tough term. It was proposed to maybe not even use it, but we gap fill that compliance demonstration. You can't gap fill standards. You don't look at a process and say, I'm gonna, the book says 3 pounds an hour, I'm gonna go with 2. But you do come in and establish that compliance demonstration methodology, testing, that monitoring to do so. So again, hard to read up there, but there's a fairly complex equation to set an SO2 standard in this regulation. It allows smaller emitters to have a, per fuel input higher limit. So that's pretty common in air pollution. The larger the unit, the more it has of potential emissions. It's allowed to emit more, but it's a tighter per unit of operation, so a more efficient operation. And this differentiates solid from liquid and gaseous. And so if you have a diesel boiler, you're going to get the same SO2 limit as a natural gas boiler. Natural gas has virtually no sulfur in it, so there's very little sulfur dioxide emissions from those. But again, it would get the same limit as a diesel boiler, which in the past had a lot of sulfur in diesel. They've lowered that, but there's still a good bit more than in any natural gas fuel. So when you set that limit, fairly straightforward, you look at the fuel type, you look at the boiler and its design, and you may require a control device if it's a diesel boiler. You may require fuel certification to prove that it's that low sulfur diesel that will help it meet that standard. That's a key part in a really traditional permitting role we have. All right, next slide, please. And this is the last one. So the federal boiler NESHAP, National Emission Standard for Hazardous Air Pollutants, it's a much newer regulation. It's more specific. And again, these are all over the country at all kinds of facilities. So it really applies to a lot of people. And it's an effective rule that's got more of those details figured out for us. You'll note it's 40 CFR 63 subpart 6J. They started naming these at A. They ran through the alphabet 6, 8, 10 times. I don't think anybody envisioned quite as thorough of a program back in the original days, but you go to those regulations and it will set standards for non-major source boilers. So those FEDUCs and those minor sources, that's major for hazardous air pollutants, as a NESHAP applies to those hazardous air pollutants. And it has very specific monitoring and testing requirements, but it's still a tricky regulation. So again, apologize for the sizing, but that's the at the federal level are often written with a question and response format. So that says, what standards must I meet? And you think it's going to tell you right then, here's your standards. It tells you, you need to meet all the standards that are applicable to your source in table 1. So you go down several pages and decipher the table. So that's a skill set of our permit writers. But this rule has a one-time energy assessment. So you make sure it's running right. It has regularly scheduled tune-ups for that boiler. And then outside of the natural gas world, which although fossil fuel is a really clean fuel in the traditional sense, for any solid fuel boilers, for any diesel boilers, biomass boilers, you're going to have testing to prove that you're meeting those standards. This has really pushed good, clean, efficient gas boilers to the market. And, you know, sort of alternative energy sources, that has really been a big benefit to air quality around the country. So again, that was just a really brief permit discussion. They are really tough to understand. Staff is here to attempt to explain whether it's a specific permit or permitting in general, but we know that's a challenge for all of us. So I'll take a few questions from board members, but if folks ever want to stick around after a board meeting, just reach out, email, or call us. And set up a time to talk about our permits. All right, thank you all.
So when you have the permit applicant that has to specify the equipment and provide spec sheets from the manufacturer?
Yes.
Okay.
First, to get to understand that idea of, you know, especially when it's a new proposed project, what's going in, a lot of photos, a lot of those process flow diagrams are really helpful. Then a detailed look at the potential emissions that we review. Oftentimes we have different numbers we're going to use, but a lot of these facilities are really in tune with their trade groups, so they can provide us some information we may not have.
Thank you. Question, anybody?
Thanks.
Thank you. That brings us to the end of the director's report. You know, as usual, the air quality and enforcement staff report and the other ancillary documents were submitted electronically. Does anybody have any questions on those reports? And again, starting less than 2 weeks, we'll start the ozone reporting again. So with that being said, we will adjourn the meeting. Our next meeting will be March 18th at 10 a.m. Thank you.